Contempt of court, overturning a Supreme Court judgment, political desperation. These are some of the words being used ever since the news broke out that the central government has brought out an ordinance designating the Lieutenant Governor as an administrator of Delhi and has given it the sole authority over transfers and postings of bureaucrats serving the Delhi government. The amendment to the GNCTD Act now establishes a National Capital Civil Services Authority which makes recommendations for transfers, postings, etc. of these bureaucrats to the Lieutenant Governor of Delhi. Now the interesting thing is, on the panel of this authority which has been formed is the democratically elected Chief Minister of Delhi and two central government officers, that is the Chief Secretary and the Principal Home Secretary.
The issue is the decision taken by the authority has to be sent to the Lieutenant Governor of Delhi. The Lieutenant Governor can then send it back to the authority for reconsideration. The catch is that if the difference of opinion persists, then the view of the Lieutenant Governor of the central government will be final.
Apart from creating this authority, this particular amendment also amends Section 41 of the GNCTD Act, which gives immense power to the LG to act within his discretion. In fact, this particular amendment or the ordinance amends the statement of LG to act in his discretion to LG to act in his sole discretion, thereby giving primacy to the Delhi government and a final word in the transfers and postings of the very civil servants. This in fact flies in the face of the Constitution Bench verdict delivered last week by a Chief Justice of India D.Y. Chandrachud-led bench, wherein it was held that in matters of services apart from the three subjects such as land, police and law and order, the Delhi government or the Lieutenant Governor has to act on the aid and advice of the Council of Ministers. Now the moot question arises is, can the central government bring this ordinance in the face of the Constitution Bench verdict of May 11th, which gave Delhi government the control over the services in GNCTD? Well, to understand a bit of technicality, a judgment can always be brought in by the central government on a parliament to overturn a Supreme Court judgment only if the basis on which the judgment was based is taken away. So in this case, the Supreme Court had noted that if there is a valid parliamentary legislation, then the executive powers of the Lieutenant Governor could be modified. And it also said that the services or the control of services or the interpretation of Article 239AA was being done in the favor of the Delhi government in absence of a parliamentary legislation. So by bringing this particular ordinance or a legislation, the central government has actually taken away the basis of the judgment delivered by the Constitution Bench, or perhaps this is going to be one of the moot arguments by the central government to justify this ordinance. So now the question arises, has this happened before? Well, of course, yes. This has happened before, that the Supreme Court passes a judgment and the central government brings in an ordinance or a legislation to overturn the Supreme Court judgment. Primarily, this happened in the case recently in the Tribunals Reforms Act, when the legislation was struck down by the Supreme Court of India bench led by Justice L. Nageshwar Rao in the Madras Bar Association case. And later, ordinance was brought in which was in fact worded very similarly to the one which was struck down. There's a challenge pending to the legislation before the Supreme Court. Even now, the legislation continues to hold forth and the Supreme Court judgment is not being implemented in the face of the new legislation. What happened before was also very important in the Shah Bano case, wherein the former Chief Justice of India, Y.V. Chandrachud-led bench had specifically held that the Muslim woman can claim maintenance under Section 125 of the Criminal Procedure Code. However, the then Rajiv Gandhi-led government overturned the Supreme Court decision by bringing in the Muslim Women Protection on Divorce Act 1986, wherein it was held or wherein it was stated that the Muslim woman can claim maintenance only during the Iddat period. A later challenge to the legislation also did not survive, which led to Shah Bano only to withdraw her maintenance claim at the end of the day. Now, one of the questions which have been, getting the spotlight is this a contempt of court? Well, strictly legally speaking, it is not a contempt of court. A contempt of court is only when an authority or an institution or an entity refuses to implement a Supreme Court judgment. However, a parliament in its wisdom can bring in a legislation, or the central government can bring in an ordinance, and that could later as well become a bill or an act, and that does not amount to the contempt of court. However, a legal challenge to this particular legislation and ordinance cannot be ruled out before the jurisdictional court, and which may result in the legislation being struck down as unconstitutional. So that is where the Supreme Court or the jurisdictional court will have the last word in this case. Well, that's all. We will keep you updated about the developments between the Delhi government versus the Lieutenant Governor tussle and much more.
Subscribe to our YouTube channel and click the bell icon.